in this video, I will discuss about the trademark infringement of an intellectual property right of a business. But first, let me explain what is an intellectual property or IP and what falls under this category. I have been working in this field for more than 5 years now and have encountered a lot of trademark infringement cases all around the world. But in today, I will speak particularly about a trademark infringement case in China of Apple versus Shintong Tiandi Technology Beijing Limited for the trademark iPhone. Let me explain in brief what is an infringement. Now let me give you some facts of the case. As you can see, they have filed for the trademark application within a few months after Apple has made its announcement. Upon learning of Shintong's application, Apple has obviously filed for an opposition against the registration of trademarks. However, they have lost their case before the Trademarks Office and even applied for an appeal before the Beijing's People's Court. However, the verdict is still in favor of Shintong. So how would Apple lose this case against Shintong? According to the China trademark rule, in order to defend your right, you have to be the first to file in the country and also whether your mark is well known within the Chinese market. However, Apple has argued that they are a very well known and very famous company all over the world. But the question is, was Apple famous back in 2007 that everyone in China would know what iPhone is? Shintong has even said, the iPhone brand can blossom widely outside Apple. We will take the iPhone mark to its pinnacle and together bring more benefit to the community of iPhone consumers. For Adam Smith, he would view it as by pursuing his own interest, he frequently promotes that of the society more effectually than when he really intends to promote it. I have never known much good done by those who affected to trade for the public good. However, for Blaise Pascal, he would disagree on this. Our self-interest is a beautiful tool to throw dust in our eyes in a pleasant way. However, for Niccolo Machiavelli, he would see the situation with Smith as entrepreneurs are simply those who understand that there is little difference between an obstacle and opportunity and are able to turn both to their advantage. However, for Mahatma Gandhi, he would disagree on this viewpoint. He would state, it is difficult but not impossible to conduct strictly honest business. And further to this, Jose Marti would also argue, to use for our exclusive benefit what is not ours is theft. But despite all this, the great General Sun Tzu would view Shintong's action as a strategy. Take advantage of the enemy's unpreparedness, travel by unexpected routes, and strike him where he has taken no precautions. However, Immanuel Kant would oppose this kind of strategy. Actions belong exclusively to the person of the author, and the right, that is, that no one may deliver the same speech to the public other than his name. Kurt Huber would also further support Kant. In this sense, he would say, there is a point at which the law becomes immoral and unethical. That point is reached when it becomes a cloak for the cowardice that dares not stand up against the blatant violations of justice. Hence, we see that Sun Tzu, Niccolo Machiavelli, and Adam Smith would see Shintong's action as just mere business strategy or business intelligence. Shintong's mark is legal, and according to the Chinese law, they have not broken any rules. And at the same time, by Shintong's actions, they actually helped Apple promote their products through indirect marketing. But on a moral viewpoint, Jose Marti, Immanuel Kant, and Gandhi believe, regardless of the intention, theft is still theft, and the creator should have the sole right for what he owns or created. In this case, Shintong could have created their own trademark to use on their leather goods for the iPhone products. But instead, they took the other way and actually took Apple's iPhone brand for their own exclusive benefit. Huber sees that the law itself has become a protection cloak for the unethical behavior of Shintong. I see that the actions of Shintong to be truly unethical, since it is very obvious that it's just not pure coincidence that Shintong has registered the iPhone mark back in 2007, where Apple has announced the device at that time. They have made a long-term plan of how they're going to take this opportunity and use it to their profitable advantage. Jose Marti has made a very valid point. Apple is the original owner, as they are the ones who created the term iPhone, and therefore they are the rightful owner regardless on which products or items the term iPhone will be printed on. We see that it is very evident that Shintong has infringed the rights of Apple for the trademark iPhone. To you, my viewers, do you think Shintong's action is just a very good business strategy, or rather, it's an unethical crime committed in the business world? Milton Friedman had said, there is one and only one social responsibility of a business: to use its resources and engage in activities designed to increase its profits, so long as it stays within the rules of the game, which is to say, engages in open and free competition without deception or fraud. So thank you guys for watching, and I hope you guys have learned something about ethics and intellectual property in this short video.